All right, good afternoon. I'm Judge Steinlage. This is Division 2 of the Coconino County Superior Court. We're on the record in State of Arizona versus Francis Cruz Mendoza-Keel, CR 2025-00513. I'll turn it over to the parties to put your appearances on the record before I read the Victims' Rights Advisory.
Good afternoon, Your Honor. Kevin Kenton, Jabin Rocher for the state.
And Daniel Hartman-Strawn for Mr. Keel, who appears present in custody.
All right.
And Barbara Vogel from Victim Witness Services.
And I will read the Victims' Rights Advisory. If you are the victim of a crime with a case pending before this court, you're advised you have rights to justice and due process under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, and to a prompt and final conclusion of the case. You have a right to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's been convicted of causing your loss. If you've not already been provided with a written statement of all victims' rights, you may contact the Victim Services Division of the Prosecutor's Office to obtain one. This is the time set for a comprehensive pretrial conference and motions hearing. At this time, I believe that there's only one very straightforward motion before the court that the court hasn't already ruled on regarding the motion to amend the information to include the notice of prior felony convictions and enhancements related to that, and the state's notice of those same prior felony convictions for possible impeachment at trial, the state noting that it's their intention only to use those in a sanitized fashion, not mentioning the specific offenses, only the cause numbers, dates of offense, and existence of felony convictions. I don't believe that there's been a response to that from the defense. Is it fair to assume that there's no objection to that as filed?
Yes, Your Honor, and I apologize. Just orally, I think on the record that day we said we would have no objection, and today we'd restate we have no objection to the amendment of those charges.
All right. I apologize if you had said that. I had forgotten since then.
That's totally fine, Your Honor.
The court will grant that. I think that there's actually a written order for that also sitting in my box that I'll go ahead and just sign it just to create a written record of that also. But that's the only motion that's before the court at this point. I guess I know that everyone's working on an accelerated schedule here for this case to meet the time limits that have been set by Mr. Mendoza-Keel's assertion of his relate time. So could I just get an update from the parties as to where things are in terms of interviews, whether or not there are still motions anticipated or anything that the court should be aware of at this point? I don't know the specifics of your case. I don't know if statements by the defendant are integral to the state's case in any way, and whether or not there should be a request for a voluntariness hearing or any of those sorts of things. So I'm just going to turn it over and hear from both sides just to make sure that there isn't something that the court's overlooking or just not aware of. I can start with you, Mr. Hartman-Strawn.
Your Honor, I think the only everything's been really smooth. I think the only outstanding thing from our perspective is there's four witnesses. The fourth witness is Patrick, or three of the witnesses are the victims. The fourth witness is the civilian witness, Patrick Pavoloni. We did send dates over to the state, but I don't think we had a time set for an interview with Pavoloni yet. So that's the only thing I see outstanding from our perspective. And then on my end, I have a mea culpa because we scheduled this when I was between witnesses in another trial. And because I was right in the middle of that trial, I completely forgot to file a 15.1. So I'll be doing that as soon as this hearing ends today. I caught that today when I was over at the jail. So I'll get that filed and sent over to the state and obviously with the court as well.
All right, thank you. And from the state?
We don't anticipate filing any further motions. The state has noticed 4 potential witnesses, 2 civilians and 2 officers. 3 of them are victims, which the state will be calling. The 4th that Mr. Hartman-Strawn referenced, Mr. Pavoloni, is a civilian. The state did notice him. We're not certain we'll be calling him as a witness. I think there has been work to get a interview date set up with him. I don't believe a date has been set yet, but I do believe that is his anything he witnessed in his any testimony would be somewhat minor in the grand scheme of the case. As far as any other motions or voluntariness, the state, I guess, reserves the right to introduce statements to the defendant as party opponent statements. At this time, there's none that come to mind that we're specifically planning to do, but I guess that could come up. We will be playing portions of body camera of the alleged assaults on the officers, and during which I think the defendant makes some noises or maybe words, statements, but I don't think there's anything like such as, an interrogation room later where there's a question of whether that statement was voluntary. Any statements are contemporaneous with the alleged assault.
All right. Well, if there's any disagreement about that between the parties, I certainly want to be on notice of that. I'd rather have that addressed prior to the trial starting. I don't want to be taking that up in the middle of trial on the jury's time. So let's make sure that if there is any discrepancy as to that, or if there's a stipulation perhaps to watch the video without the sound, if there's something useful in the sounds that are there, that would be another way of addressing it. But I'm going to leave that to the parties to figure out or bring to the court's attention if it's problematic. One other issue, I know that the parties only indicated 2 days for trial, and we're set for 2.5. But I wanted to again confirm that I've needed that Friday that we didn't schedule for Friday or for the trial. I want to confirm that that's still the case, as I have mounting need for time on that date. I just want to confirm that everybody's still in agreement that the 2.5 days as we have scheduled now is sufficient from everybody's perspective as you've continued to work on the case.
From the state's perspective, I think there's a good chance we'll have this to the jury by the end of the day, Wednesday. I think we should be able to do jury selection and opening statements on Wednesday. I imagine starting state's presentation of evidence Wednesday, sorry, did I say Tuesday? Wednesday morning, starting state's presentation of evidence. I think we should be able to get through the witnesses the state calls that morning, maybe into the start of the afternoon, but certainly by mid-afternoon we'll be done. And then I guess it would be up to the defense if they're planning to, what their plans are, but, and then with jury instructions, things of that nature, closing statements, either late Wednesday or Thursday morning.
All right. All right, so it sounds like that's still the case. Do you agree, Mr. Hartmann?
Yes, Your Honor. I mean, I'm fairly new to trials as well. In my experience, like that jury selection may just take the entire first afternoon, especially with instructions and stuff. But even I think if we start opening then on Wednesday, we'll get through, I believe, all the witnesses on Wednesday. In worst case, we're doing closing by Thursday morning. So I'm in agreement with the state. I don't see any way we go over the 2.5 days.
Okay, sounds good. I don't have anything else for the parties unless there's anything else that you want to ask of me.
There actually is just one scheduling issue. As the court may recall, yesterday I had a Rule 11 that was remanded to Division 3, and a trial setting conference was set at 1:30 or 1:15 on that Wednesday, the second day of our trial. That case has been going on a long time, and that trial setting change of plea could take an hour or two. I'm happy to ask Division 3 for a continuance, which I think will be granted. But I just wanted to raise that issue and see if the court of the parties thought it would make sense to start trial on Wednesday afternoon closer to 2:30 or 3. I just wanted to raise that.
I would like to use every minute that we have. I think everybody that's had a trial in front of me knows I want to use as much time as we can, as efficiently as we can, to keep keep the number of days that we pull the jurors in as small as possible, because it is an impediment to people's lives. And frankly, I want jurors to have a good experience where they leave here feeling like we're efficient, utilize their time wisely, and then go off and tell their friends that, so that people show up when we summons them in and stuff like that. So my preference is very strongly is going to be to start as soon as we can in the afternoon. I usually give everybody an hour and a half, as you know, for lunch. If it would be helpful to take a break later and do something like that, I would be amenable to that. But I would probably just ask for the continuance from the other division. The date that you were given was just a date that we were given, and they can, I'm sure, come up with others if you've got a conflicting trial.
That's what I thought you'd say. I just wanted to just raise it here, but I'll go ahead and do that.
I appreciate it, but I just don't want to build dead time into the trial for the jurors. I can tell you, I read all the responses, the reviews that they have after the trials, and they hate that. And they are annoyed by us when we don't use their time wisely from their perspective, even though we all know that we're here working very hard during all of that time where they feel like we're doing nothing. So I try to do that as little as possible for that reason, because no matter how much you tell them in the instructions that even though there will be delays, and we're all be assured that we're working hard on this case, or the judge is caught up working on other cases, it doesn't feel like that to them wherever they are. It leaves a bad taste in their mouth. And so as much as possible, I want to be mindful of their time. And I do want them to have as much as it can be a positive experience, because I think that's good for all of us as we need other people to come in down the road too. So I'd prefer you ask for a continuance, though. I appreciate the dilemma, though. Anything further?
I was just going to say, I actually set this trial while the state allowed me an extra 15-minute break during our lunch break for the trial we were in at the time. So just if it does come to it, we'll have no objection to fitting that in. So,
all right, very well. All right, in that case, we are adjourned. Thank you.
thank you, Your Honor.